This video is intended only for lawyer licensing candidates. There are 3 ways for lawyer licensing candidates to complete the experiential training requirement. Number 1, the articling program. Number 2, the law practice program in English, or the Programme de pratique du droit in French. And lastly, the Integrated Practice Curriculum, IPC. In this section, we will focus on the articling pathway. Candidates are expected to secure their own articling placement to complete the experiential training component. Detailed information on recruitment activities and guidelines, as well as other resources, are available online in the experiential training section of the website. There are many different arrangements and practice settings that can support an articling placement. In addition to the traditional full-time articling placement in Ontario, the Law Society also permits, in appropriate circumstances, joint articling placements with 2 or more principals, part-time articling placements, as well as national and international articling placements. We encourage you to consult the website if you're considering any of these options, as they sometimes have additional requirements and a service request must be submitted for the Law Society's approval. Service requests can be initiated on the home page of LSO Connects by selecting the Service Request tile. During an articling placement, you're permitted to take up to 10 business days off without it affecting the length of your placement. This time can be used for vacation, study, or sick days. If you're away from your articling placement for more than 10 days, you will generally need to extend your articling term. For any employment absences that do not fall within the allotted time off, candidates should work directly with their supervising lawyer, who is ultimately responsible for managing the candidate's time off. If you decide to write the licensing examinations during your articling placement, your principal must give you 7 days free of articling duties from each of the licensing examinations. Please note that this obligation only applies if it is your first attempt at each exam, and that any study days you take count towards the total 10 days off to which you're entitled. We will now touch upon the key submission requirements of the articling program. First, note that before the articling placement even begins, your principal must be approved by the Law Society to serve as a principal. This is not a requirement for you as a candidate, but it's important that you be aware of this requirement because if your proposed principal is not already approved, your placement start date could be delayed. If your principal does not become approved, you would have to secure another placement. We are not able to credit time that you spend working for a lawyer who has not been approved as an articling principal. If the lawyer is going to act as your principal and has not had an articling student before, it's important that your potential principal is reminded to submit a service request to be approved as a principal and to do this well in advance of the placement commencing. The first requirement for you as a candidate is the start of placement record, which must be submitted at the beginning of your placement, along with payment of the experiential training fee within 10 business days after your articling placement starts. It's important that before and during your placement, you check your LSO Connects account often, since that is the primary way that the Law Society will communicate important articling and licensing information to you. It's also important that you notify us of any changes in your placement or your personal information as soon as possible. Your LSO Connects account is the best way to contact the Law Society about anything related to the licensing process. At the end of your placement, you must submit an end of placement record. Submission of this end of placement information is required for you to become eligible to be called to the bar. So, to recap, there are 2 key items that you as a candidate will be responsible for submitting. Number 1, the start of placement record, which must be submitted at the beginning of your placement. And number 2, the end of placement record, which must be submitted at the end of your placement. Some candidates have questions about their rights of appearance while articling or in the LPP or PPD. The Law Society governs who may provide legal services and the scope of these legal services. It's important that you understand what you are permitted to do as an articling candidate. During articling, you may appear on certain matters before courts and tribunals. But before you make any appearance on any matter, the first step you should take is to consult the Rights of Appearance page on the website, which provides a detailed list of the types of matters you can appear on. In addition to ensuring that your matter falls within that list, you and your principal or supervising lawyer must ensure that the lawyer's attendance is not necessary and that you are adequately supervised and properly prepared, and that the matter is appropriate for your level of training, experience, and ability. Please note that Ontario courts and tribunals are entitled to control their own processes. So although the Rights of Appearance page set out certain matters on which the Law Society permits candidates to appear, it's always advisable to consult any applicable enabling legislation, rules of practice, rules of procedure, and practice directions. You should also contact the court or tribunal in advance whenever possible to obtain express permission to make an appearance. After you have read the webpage, if you still have questions about your rights of appearance or would like some clarification, please feel free to contact us. When you do make an appearance, you're also obligated to identify yourself as an articling student or work placement candidate. You may also use the term student at law. If you've completed your experiential training requirement, are not subject to a good character investigation or hearing, and you would like to continue to provide legal services before you're called to the bar, you may do so under supervision for up to 6 months by completing an initial supervision agreement with your supervising lawyer. You must use the initial supervision agreement form provided on the Law Society website. You do not need to submit the agreement to the Law Society. If, following that 6-month period, you wish to be supervised for up to another 6 months, then any further work must be done under the supervision of a principal approved by the Law Society. To qualify for an extended supervision agreement, you must complete an extended supervision service request in LSO Connects, which includes submitting an extended supervision agreement signed by you and your supervisor for the Law Society's review and approval. You can find a copy of the extended supervision agreement form on the Law Society's website. In total, candidates are only permitted to work under supervision agreements for a maximum period of 12 months. Please consult the Supervision Agreements page on the Law Society website for further information about initial or extended supervision agreements. If you have any questions, please contact us via your LSO Connects account.